A very good evening to you, ladies and gentlemen. We warmly welcome you to the first episode of the webinar series held in English for the year of 2023, organized by the Seminars Committee of BASL 2022-23 on an interesting topic of Small Claims Court Procedure Act number 33 of 2022. As you all know, this webinar series is conducted on the Zoom platform. However, for those who have been unable to register on Zoom, could also join by watching the live stream on the BASL YouTube channel. First of all, I would like to thank the Seminars Committee of the BASL headed by Mr. Isuru Balapatabendi, Secretary to BASL, and also would like to take this opportunity to thank the President of BASL, Mr. Salih Piris, PC, for all the support and guidance given to us in organizing this webinar series. Today's topic, as I mentioned earlier, is Small Claims Court Procedure Act number 33 of 2022, and we have a distinguished panel of experts joining us today to share their knowledge with us. So I now take this opportunity to introduce the esteemed panel and the moderator for the day. Firstly, I would like to welcome Justice Dr. Juan Fernando. His profile will be now shared on the screen. I would also like to welcome President's Counsel, Mr. Jagat Vikramanayaka, and his profile will be now shared on the screen. And the moderator for the day is Mr. Harit Dimel, Attorney at Law, and his profile will be now shared on the screen. And if you come across any questions or any points to clarify, please feel free to key it in on the chat box on Zoom, which will reach the moderator. And now I will hand over the proceedings to the moderator. Over to Harit.
Thank you very much, Kavishan. Good evening to all the viewers joining us on the Bar Association seminar for 2023. Thank you very much for joining us. And I'd like to also thank the Bar Association, including the President of the Bar Association, Mr. Saria, President's Council, and also Isuru Balapatabendi, the Secretary of the Bar Association, as well as the Seminars Committee, for inviting me and this esteemed panel to be a part of this very interesting first seminar on the Small Claims Procedure Court. As explained by Kavishan, we have a very distinguished panel with us, and I don't want to take too much time, except to say that the Small Claims Procedure Act came into effect 33 of 2022, came into effect on the 1st of January 2023. There is a change in the substantial law under the Judicature Act created by 33 of 2022 and read together with 34 of 2022 for the Judicature Amendment Act. And we will have a seminar where we will have two presentations. Firstly, by Honorable Justice Juan Fernando, who will deal with the intentions of the Small Procedure Claims Act and the objective that was brought in, specifically dealing with the salient provisions governing settlement and the character of the pleadings, as well as what in fact is a small claim for the understanding of our worship. It will be followed by a presentation from Mr. Jagat Vikramanayaka, President's Counsel, who will emphasize more particularly on the practitioners or the pleaders' role under the Small Claims Procedure Act with regard to the pleadings and as to the conduct of the trial. So without much ado, let me invite Justice Dr. Juan Fernando to commence the first proceedings of this webinar by way of introduction to the Small Claims Procedure Act, after which I will invite the next panelist. Over to you, sir.
Thank you, Harit. The Small Claim Courts Procedure Act number 33 of 2022 came into effect on the 1st of January 2023. There are, however, very interesting questions are being asked about the concept of the Small Claim Court. What are the objectives of the Small Claim Court? What is the jurisdiction of the Small Claim Court? Why do you want a Small Claim Court? what are the claims that can be filed in the small claim courts? What are the claims that are excluded from the jurisdiction of the small claim court? What is the procedure? Is it formal, informal, or combination, or a special procedure? What is this concept of settlement? Is it the same settlement which is envisaged in the Primary Court Procedure Act, or is it a different one? And will it achieve the objectives when there is no separate courtroom? So what are the differences of the small claim court from the district court? Is it the same small claim court which was introduced by the Judicature Act earlier? So those are the issues that are being now raised in the justice sector. So first of all, what are the objectives of establishing the small claim? This small claim court will be a unique one. It will be a unique one. It is designed to increase access to justice for small monetary claimant, so that small monetary claims can be resolved in a separate court, claim the small claim court, fast, inexpensively, and in expeditious and less complicated and cost-effective manner. So the idea is to ease the workload of the district court, so that the small claims that are filed in the district court will be removed to the small claim courts, or the new claims would be filed in the district court, so the district judges will have sufficient time to deal with the high monetary value claims. So this will be a simple procedure in comparison with the district court. I will explain as to why this is a simple procedure. This will be a mechanism which will not invalidate the proceedings. It will not impede the administration of justice because of the formal defects, irregularities, and the technicalities, unless substantial prejudice has been caused to a party to occasion the failure of justice. So the idea is to provide relief to small litigants who have a small claim but unable to take it to a court because of the delays and the expenses. So there has to be a novel mechanism to be introduced to give redress to such litigants whose claim will not be more than rupees 1.5, excluding interest, so that such claims can be concluded within the period of 1 year and 6 months, namely 18 months. So those are the objectives of establishing small claim court. So now the interesting question is then, what is a small claim? Now, small claim is defined in the Small Claim Procedure Act. Small claim is a debt, damage, demand referred to in the 7th schedule to the Judicature Act, which, however, does not exceed the sum specified in the Judicature Act in section 29A2, or any such amount as may be fixed by the minister from time to time in terms of section 29A2 of the Judicature Act. So the small claim is limited to debt, damage, demand referred to in the 7th schedule of the Judicature Act, which does not exceed the sum specified therein, that is rupees 1.5 excluding interest. Now, what is the jurisdiction then of the small claim court? The jurisdiction of the small claim court is set out in the Judicate Act, section 29, 2 of the Judicate Act. Now, subject to section 3 of the Small Claim Court Procedure Act and chapter 5A, mainly section 29 of the Judicate Act, any other limitations imposed by any law, any action for the small claim, for a small claim, should be filed in the small claim court within the local limits of the judicial division in terms of section 9 of the Civil Procedure Code. So, action can be filed in a case where the party defendant reside, cause of action arises, or the contract sought to be enforced was made. So, the jurisdiction of the small claim court is set out in the 7th schedule to the Judicate Act, that provides that all actions specified in the 7th schedule shall not exceed a sum of rupees 1.5 million, excluding interest, or any other amount as may be fixed by the minister from time to time. In short, an action specified in the 7th schedule to the Judicate Act will not exceed the sum of rupees 1.5 million, excluding interest. Then, what are the, now this is the monetary jurisdiction of the small claim court. However, there are certain claims which would be excluded from the jurisdiction of the small claim court. So there is a monetary jurisdiction, which is 1.5 million excluding interest, and there is a subject jurisdiction. The subject jurisdiction is set out in the 7th schedule to the Judicate Act. So a small claim will be limited to the claims specified in the 7th schedule to the Judicate Act. 7th schedule provides any action for the recovery of any money. It has to be a monetary claim, the debt, fee, payment, damage, demand, including action for the recovery of damages on accident or personal injury, or any such similar category. So that is the first element. An action for the recovery of money, where the value does not exceed rupees 1.5 million excluding interest. So that is the first subject jurisdiction of the small claim court. There is a second element. Small claim court also can be, small claim can be filed in respect of a claim for the recovery of movable property. However, no action can be filed in respect of immovable property, only for the purpose of recovering movable property, where the amount is limited to 1.5 million, excluding interest. If the value of the action is more than 1.5 million, then no action can be filed in the small claim court, subject to one or two exceptions. So the third category is any action for the counterclaim in respect of any cause of action specified in item 1 or 2. If an action is filed for the recovery of money, which is less than 1.5, there can be a counterclaim, then action for the counterclaim can also be filed in the same action. So the third category is action for the counterclaim can also be filed. Then the fourth category is any other jurisdiction that is conferred upon the small claim court by other law. So those are the subject jurisdiction of the small claim court. Now the question will arise whether in order to bring action within the jurisdiction of the small claim court, whether a portion of the claim can be abandoned or relinquished, or whether a cause of action can be joined in the small claim court. Section 3 of the Small Claim Court Acts permit two or more causes of action to be joined. However, it is important to understand that in terms of Section 3 of the Small Claim Court Act, a cause of action in a small claim shall be limited to Chapter 5A, that is Section 29 of the Judicator Act. That means any cause of action shall be limited to the monetary jurisdiction and also the subject jurisdiction of the set out in the Judicator Act. However, a plaintiff can join two or more causes of action subject to, again, Section 29A of the Judicator Act. That means causes of action can be joined, but shall not exceed the amount specified in the Judicator Act, which is 1.5 million, excluding interest. Now, the question is whether a portion of the cause of the claim can be abandoned in order to bring the action within the jurisdiction of the small claim court. Now, if the claim is more than 1.5 million, then such an action cannot be filed in the small claim court. However, it may be possible for a party who wishes to file action in the small claim court to relinquish, to abandon a portion of the action in order to bring the action within the jurisdiction of the small claim court as set out in Section 4. So assuming plaintiff has a cause of action which is more than 1.5, which is 1.6. But if the plaintiff wishes to bring the action within the purview of the Small Claim Court Act, plaintiff can abandon that portion. He can abandon one portion, 100,000, and plead in the plaint that he is abandoning, is relinquishing that portion of the claim in order to bring the action within the jurisdiction of the small claim court. But however, if we decide to relinquish that portion, we will not be able to file any other action in respect of that claim. But there are situations where a plaintiff would like to abandon a portion of the claim in order to bring the claim within the jurisdiction of the small claim court. Then, however, there are certain actions which cannot be filed in the small claim court. For example, any action filed under the Chapter 53 of the Civil Procedure Code, that is basically the summary procedure on the liquid claims, cannot be filed in the small claim court. And further, any action for the recovery of money to which the special procedure, special provisions are made under any written law cannot be filed in the small claim court irrespective of the value of the cause of action is less than 1.5. Why is that? Action for the summary procedure on liquid claims, has several steps to be taken so that such claim are not suitable for the for resolving in the small claim. Now, take for example a debt recovery procedure. Debt recovery procedure, there is a procedure to be followed. You have to file the plaint, affidavit, proxy, decree nisi. Then instrument will have to be, a suit will have to be filed. Then you have to tender the decree nisi and service thereof, copies of all the documents. And then the court will issue a decree nisi. Then the defendant will have to come and get leave. So such a procedure is not suitable for the smaller litigants who will come before a small claim. Then there is a summary procedure on liquid claims, and also the summary procedure, which is set out in the Civil Procedure Code, it will not be applicable to small claims. And also the mortgage actions will not come within the purview of the small claim court, because there is a special steps to be taken in such actions, so that even if the value is less than 1.5, such actions cannot come within the purview of the small claim court. So the action filed under the Debt Recovery Act, action on summary procedure on the recovery of money, mortgage action filed under the mortgage action filed under the Mortgage Act will not come within the purview of the small claim court. Now, in addition to these limitations, there are at least two limitations. For example, any dispute is in relation to any debt or payment that falls within the sum specified in Section 7 of the Mediation Board Act. The present value is 500,000. Then, unless you get the certificate of non-settlement, you can't file action in the small claim court. Further, if there is an arbitration clause between the parties, and the parties have agreed to refer the matter to arbitration, and one of the parties object to the court exercising jurisdiction, such action cannot be maintained in the small claim court. So those are the main features as far as the jurisdiction and the limitations are concerned when an action is to be filed in the small claim court. Now, having said that, if smaller litigant wishes to file an action in the small claim court, what are the pleadings? Is it the plaint, answer, and if any, replication only? Now, we have noticed in most of the cases fail because there is no homework done. No relevant documents are tendered to court at the appropriate times, and pleadings are bad, so that relevant documents, necessary documents are not filed on time, so actions fail. Now, in a small claim court, if you want to file an action, the pleadings are basically the plaint, answer, and replication, but in order to follow the procedure, there is a special procedure which is set out in the small claim court. That is, if you want to file an action, the plaintiff will have to file the plaint affidavit in support of the facts stated therein, and also the documents. That is very important because you have to file the documents which are in your possession of power. You don't want to file, you can't file, you may not be able to file all the documents which are not in your possession of power. But if those documents are in your possession of power, you can annex those documents. So you have to file the plaint, you have to file an affidavit, you have to, if you have witnesses who are ready to give an affidavit and available, then you can also file affidavit of your witnesses and annex those affidavits and the documents to your pleadings. Then the defendant also can file the answer together with an affidavit in support of the facts and also the documents which are in the possession or the power of the defendant. So that is important. Defendant will also file the answer together with the affidavit, and also if there are his witnesses who are willing to give an affidavit, he also can annex the affidavit with the answer, with the relevant documents. Now, in the small claim court, the answer has to be filed within 1 month from the date of the appearance, unless in appropriate circumstances, court may grant time. So the replication can also be, if it is allowed, if there is a claim in reconvention, replication may be allowed. The plaintiff can also file the replication together with an affidavit and also with the documents, if any. So those are the pleadings. It is different from the pleadings in the district court because you have to file the basic pleading, plaint, answer, and replication, if any, together with affidavits and the documents which are in your possession of power. So that what will happen in the small claim court, action is filed in the small claim court, where the action, the value is action is limited to 1.5, but there is a claiming reconvention which exceeds the monetary jurisdiction of the small claim court. What will happen? Section 14 provides the answer to that. Action is filed by the plaintiff for 1.5 million. Defendant has a counterclaim, which is 1.7. So does that mean the defendant cannot proceed with the counterclaim, which is more than 1.5? No. Section 14 says, where the claiming reconvention exceeds the monetary jurisdiction of the small claim court, the small claim court may, notwithstanding the sum stated therein is in excess of the monetary jurisdiction of the small claim court, hear such claiming reconvention and enter decree for the purpose of avoiding multiplicity of actions. That is important because the plaintiff action is limited to 1.5, but defendant has a claim in reconvention which is arising from the same claim. Then he can't be asked to go to the district court in respect to his claiming reconvention. So that claiming reconvention, despite it is more than 1.5, will proceed in the small claim court. Then there are situations where the plaintiff is filed in the wrong court. We'll take, for example, a plaint which should have been filed in the small claim court is filed in the district court, or the claim which should have been filed in the district court is filed in the small claim. The plaintiff has filed the action in the wrong court. In such situation, Section 47 of the CP, Civil Procedure Code, will apply. So that in such situations, the plaintiff will be returned to be filed in the appropriate court. However, there are situations when the plaintiff is returned, there will be a gap. The plaintiff is returned today, action will be filed after 1 or 2 months. And by the time the action is filed, the action may be prescribed. So to avoid such a situation and prejudice being caused to smaller litigant, Section 5 of the Small Claim Court Act provides the period between the date of the institution of the action and the date of the return of the plaint will be excluded in computing the period of prescription, notwithstanding anything to the contrary in any other written law. It often happens by an oversight, by a mistake. Lawyers may file the plaint in the wrong court, but by the time the plaint is returned and the action is filed in the correct court, claim would have been prescribed. So these are the small claimants. File small claim, the small claim court, in order to prevent the prejudice being caused to the litigant, the period between the returning of the plaint and the date of the institution of the action will be excluded in computing the period of prescription. Then, as I said, the pleadings in the small claim court will be plaint, answer, and the replication, if any. There is a special procedure. In addition to the pleadings, you have to file affidavit and the documents which are in your possession and where the witnesses are ready to give affidavits. Then, usually in the district court, amendment of the pleadings will be allowed only under certain restrictions. So under the Small Claim Court Act as well, no pleadings will be, for amendment of pleadings will be allowed unless the court is satisfied that the grave and irremediable injustice will be caused to such party if the amendment is not allowed. And also the party so applying has not been guilty of flashes. So that this is the same principle which applied in the district court. However, the small claim court can, at any time, on an application being made by any party, correct any clerical or arithmetical mistakes in the pleadings. So that usually in the district court, after the pleadings are over, matter will be fixed for pre-trial. Small claim court, there won't be any pre-trial. Pre-trial may not be suitable for smaller disputes, smaller claimant who come to a small claim court to get his money back. So that there is no pre-trial in the small claim. Then what will happen if the pleadings are over? Matter will not be fixed for trial. If the pleadings are over, unless there are some default, if the defendant failed to file the answer, then matter will be fixed for ex parte. However, if the answer has been filed and if there is a replication which has already been filed, what will happen is that the matter will be fixed for a settlement. That's a new concept that has been introduced in the Small Claim Court Procedure Act. This is what is known as the settlement conference. What is settlement conference? Is a conference where the judge sit with the lawyers and the litigants as shown in slide 3. I will show you that slide as to how it should happen in the small claim court. Saran, can you show that? Right. Yes, I hope that you will see this picture. This is the settlement conference that should happen in the small claim. And you will find the judge will be the presiding one, and the lawyers will sit at the bar table or a conference table. And you must give an opportunity to the litigants to sit behind the bar table. That is very crucial. That is a very novel concept in the Small Claim Procedure Act. You need the lawyers, you need the litigants at the settlement conference. Otherwise, this settlement will not work. that is why I said at the very outset, this is not the settlement which is envisaged in the Primary Court Procedure Act. This is a settlement. The judge will make every attempt to ensure that the parties will settle the matter. So if the case is settled, that is the end of the matter. So for that purpose, you must get the litigants also to participate in the settlement. So that if the case is settled, that's the end of the matter. However, what will happen if the case is not settled? If the case is not settled, this matter will be fixed for trial. However, I must say that settlement, for the purpose of settlement conference, this is a mandatory requirement, and the attendance of the parties is very, very important. However, the party can be represented by any other agent, provided there is some authority given by them, so that the attendance of the parties is very, very important. And unless there is a deliberate attempt by one of the parties to avoid the settlement conference, of course, we may be subject to cost. So if the case is not settled, what will happen is this matter will be fixed for trial. So I will just explain the two options. Slide number 4 will show the two options which are available in the small claim court. If the case is not settled, what will happen is court may, under section 21(2) of the Act, if the judge is of the opinion, with the consent of the parties, that the final judgment can be pronounced solely on the pleadings, affidavit, and the document without oral evidence. Judge may hear the parties by way of oral or written submissions and fix the matter judgment. This happens only where the judge is of the view this is appropriate, because you have the court, all the pleadings are before court, affidavits are before court, all the documents are before court. If the judge is of the view, well, all the relevant documents are there, then judge, with the consent of the parties, may, after hearing the parties, deliver the judgment. Or judge is of the view, though it is not possible, you need oral evidence, then the judge will proceed to hear the case. Judge will record admissions, that is mandatory. And if the judge is of the view, issues should also be recorded, because there are some special matters, there are certain complex situations. So then the judge will record issues and proceed to hear the actions. That is how it will happen. In short, the structure of the Small Claim Court Act is slide 5 will show. Slide 5. Plaintiff affidavit, documents, then the answer will be filed, affidavit, and the documents with the replication, if any, and then matter will be fixed for settlement. But in the meantime, any party can make discovery application. A party who was unable to annex the relevant document will now discover the document by making application to the Small Claim Court and seeking documents which he could not find and with the pleadings. So he will make an application, court will issue commissions, court will call for the expert report, court will make orders directing private institutions, government institutions to issue certified copies. And once the commission reports come and the documents are discovered, the court will direct the party to submit that document by an affidavit, so that by the time the matter comes for the settlement, all the relevant documents which are needed, which the plaintiff could not have filed with the plaintiff, or answer or application will be before the judge. So the judge will be in a position to conduct a reasonable settlement. If it fails, the judge will fix the matter for trial and the normal trial procedure will apply. So that is the structure of the small claim court. Harith?
Thank you very much, Honorable Justice Dr. Juan Fernando. As we understood from the presentation of Justice Dr. Juan Fernando, there seems to be a change or a need to change the paradigm of civil litigation. Mr. Jagati Kamarayaka, President's Counsel, I would like you to come in at this point to elaborate where does the Small Claims Procedure Act change the duties and the roles of the lawyers and the pleaders who are to come before this court, especially with regard to how they must frame their pleadings, what is the lawyer's role in the settlement, and what is the lawyer's role if the matter is to go to trial. I leave it to you now, sir.
Thank you, Harith. And I must thank the Bar Association for having me here for this seminar. And also, I must congratulate Justice Juan Fernando, who headed the committee, who really drafted this particular act, and the other members of the committee, because they have done a wonderful job in drafting this act. There may be certain, we might encounter certain difficulties in following certain things, very little though. But overall, it's a very good piece of legislation. And I think if we can really give effect to this law, a lot of people who have litigation for small claims would definitely come to court, because we are ready to give them redress for their grievances under this particular act. So coming back to what Harith wanted me to address on, I think that before we proceed with the provisions of the act, what we need to understand is, at the moment, there is some kind of a reluctance on the part of the litigants to go to court for small claims. So the Small Claims Act deals with monetary claims, nothing else. It's not divorce, it's not land, it's only about the small money claims. So small money claims, even we as lawyers, when clients come to us to file action for a sum of 1 million or 1.5 million, there are instances where we discourage litigants from going to court, because we know when you ask a client to go to court for a claim of 1.5 million, the trial might take 6-7 years in the district court. Then there's an appellate procedure. Finally, once the party gets the judgment in their favor after prolonged litigation, probably the value of 1.5 million may not be there at after 15 years, by looking at the devaluation of the rupee in this country. So it's always best if we can encourage the litigants, or encourage the lawyers especially, to follow the procedure laid down in this act properly and give effect to it. I'm sure we may be able to achieve a lot of things through this procedure. So when it comes to the Small Claims Court procedure, as Dr. Fernando, Justice Fernando very correctly said, this is a complete different procedure. It's a special procedure act, as the act says. So the special procedure, but of course, when you look at the procedure, the first thing is you need to file action, you need to file a plaint. So when you file a plaint in the district court or in the Small Claims Court, virtually the requirements of a plaint in the district court is there. So if you look at section 7, which deals with the plaint, section 7 says section 40 and the 46, the provisions in section 40 and section 46 will apply to the plaint filed in the Small Claims Court as well. So when you look at section 40 and 46, section 40 speaks of requisites of a plaint, and section 46 specifically says, if it does not state correctly and without prolixity, the several particulars herein before required to be specified therein. So what is specified herein before or prior to section 46.2 are the requirements of a plaint as stated in section 40, section 40 to section 45. So if you take section 41, which only applies to land cases, other than that section, I think all the other sections apply to small claims court as well. So you need to follow the usual procedure in instituting action in drafting the plaint. But there is a difference in the small claims code. So the small claims code, in my opinion, is really a courthouse for juniors, where the juniors can appear. So juniors can draft plaints without any hesitance, because section 33 of the Act specifically says there is no room for technical objections or technical, like the action will not be defeated as a result of any technicality in terms of section 33. So this is ideally a courthouse where the procedure is very simple. You don't have the normal pressure that you have in the district court in drafting a plaint. So this is absolutely a golden opportunity for juniors to appear, juniors to draft plaints, juniors to institute action, and to proceed with the case. But for that, we all will have to be set. We'll have to have the mindset to give effect to the Act. So that's the most important thing. So if we are not ready to take upon or take the case and to give effect to the Act, we will definitely fail in the small claims court. So that's what I'm saying. So it's an ideal courthouse for juniors. You have all the opportunities now. There is a plaint that has to be drafted. You need to follow the procedure, or you need to follow the provisions of the Civil Procedure Code in relation to a drafting of a plaint. But yet, if you make a mistake, if there is any technicality involved in your plaint, doesn't matter, you still get the opportunity to rectify that and proceed with the case. So when I come back to the provisions of the Act, once you file the plaint, as His Lordship very correctly stated, if you want to bring that action within the jurisdiction of small claims court, you can abandon part of the claim if you so desire. So when you abandon part of the claim, as envisaged in section 4 of the Act, what applies is section 33 of the Civil Procedure Code. So if you abandon, you may not be able to litigate for the portion that you abandoned. But as His Lordship very correctly stated, now here the monetary jurisdiction is 1.5 million. 1.5 million excluding interest. So there could be interest made so for about another 1 million or so. So we are looking at a case which altogether involves a sum of rupees 2.5 million. That's not a small claim, but of course it's a good claim for a litigant. But in the context of small claims court, it's a small claim. So when you file an action to recover 1.5 million, the procedure is quicker, simple, and we know there is no room for technicality. So the interim orders that the court will have to make in the process may be very less. So the delay is minimum. I think this is what I said. It's an absolutely fantastic piece of legislation, because this kind of act, I think Dr. Juan Fernando and the committee had looked at every detail in relation to small claims in drafting this law. So if you want to join two claims, we say there are two claims arising out of the same transaction. You can join those two, probably, but still it's within the monetary jurisdiction of 1.5 million, excluding the interest. So thereafter, the other thing that you need to keep in mind, when His Lordship said that you can return, the court can return the plaint to be filed in the proper court. If you had gone to the wrong court, to be filed in the proper court in terms of section 47. So the very progressive provision, the new part to the section has been added in the Small Claims Act. That is the prescription period from the time of the filing action and to the date of the return of the plaint. that particular time period is excluded in computing the time for prescription. So that's a very, very progressive provision. I think we should add that particular portion to the original section 47 in the Civil Procedure Code, because we have a lot of complexities in deciding the court's jurisdiction in most of the time. Sometimes, like we need to go after, we need to find out the defendant, if you go on the basis of defendant's residence, you need to find out not only his address, but what is the Grama Seva division. There could be change in Grama Seva divisions. So there's a lot of issues are there in relation to jurisdiction. But unfortunately, our section 47 does not speak of prescription. So the original, I'm talking about section 47 of the Civil Procedure Code. But in this particular section, it's section 5 of the Act, it says when the plaint is returned for want of jurisdiction, you can go to the correct court, and the time period from the date of filing action and the date of return, that particular time period is excluded from computation of time period for prescription. So it's a very progressive provision. So you don't have that pressure also, even if you have a doubt. I'm not saying that, just to make use of this provision and go and file the case where you want to file, and don't abuse the provision. But of course, if you have a genuine difficulty, you still do not have that pressure, which you will have otherwise when you file action in the district court, because if the action is dismissed, or if the plaint is returned for want of jurisdiction, by the time you go to the other court, your cause of action might be prescribed in law, where you will not be able to proceed with the action any further. So that difficulty, the drafters have taken away in this particular act. So then, once you file the plaint, you need to see what is your duty now. If you look at the provision, the provision that is section 7 of the Act, section 7 of the Act, which says that you need to follow section 40 and 46. Section 8 says, along with the plaint, the other documents that you need to file. I would prefer, with all due respect to his lordship and the committee, I would prefer if we could have a provision, or if you could amend this section to say a duly certified true copies by the instructing attorney to be filed, because it says, when you look at this section, that you need to you might have to file the original documents. Filing original documents might be a problem, because we don't have proper systems in most of these courts. We don't have facilities to protect the document sometime when you file it before even you start commence the case. So I personally think it's best if you are able to file certified copies instead of originals at the time of filing the plaint. So what are the documents that you can file? Look at section 8. The section 8 says the instrument, contract, agreement, bill of exchange, promissory note, check or document sued upon, and all other documentary evidence relied upon by him, if any, in his possession or power, in support of the facts on which the plaint is based. So, section 50 of the Civil Procedure Code says, when you're suing upon a document, you need to submit that document to court. But here, what we are saying is, the document upon which you sue, and all other relevant documents which are in your possession or power to be submitted to court along with the plaint. Now, apart from that, you file an affidavit in support of the averments in the plaint. So whatever that you have said in the plaint, you have an affidavit. This is like when you're supporting for an injunction, that you file a supporting affidavit. So if you file any action under section under chapter 53 for the liquid claims, you file an affidavit confirming the facts that you have stated in the averments of the plaint. So you have an affidavit. Now, looking at the plaint, there is an affidavit for court to be satisfied, but of course subject to any challenge by the other party when they come to court. And going further, you can file other affidavits. We say there are two witnesses. We say you're suing on a contract, and there are two witnesses. There are two people who have witnessed the contract being executed. So those two witnesses are, we will say that they are working with you or they are in your company. So you can file that affidavit. We say also there is a statement of claim. The person who has prepared the statement of claim is the accountant, but the person who is giving the affidavit in support of the averments in the plaint may be the chief executive officer of the company. So you have the accountant. So you get the accountant to verify and state that he's the one who prepared the documents. He's the one who prepared the statement of accounts. You have that affidavit also in support of the statement of accounts that you file along with your plaint. So if you really take interest in filing this action, which is for a small claim, but of course, if you take interest, proper interest in filing the plaint, then you can have all these documents ready. So when you file that plaint, along with the documents, along with all these affidavits, the defendant is compelled to set up a proper claim or rather proper defense. If he does not have a defense, if he really feels by looking at the documents, this is a claim, a genuine claim, where I have to pay, it would be very easy where the settlement, when it comes to the settlement stage under section 22 or even before filing the answer, the law says the defendant can admit the claim of the plaintiff. So I have a feeling, because it's a small claim, we're talking about 1.5 million. So then when it comes to the defendant, litigation is costly, it's time consuming. So the defendant also, when you say that there is a case, the defendant also might think, sometime you file action in Colombo, where the defendant will have to come all the way from Ayangan or some faraway place like that. So the defendant might think it's rather better for me to come to some sort of understanding and finish the matter rather than going on with this prolonged litigation. So we encourage parties also to come to settlement. We finish the matter soon. The people will be encouraged to go to court, even the claim is smaller. I'm sure if we are successful in executing, or in rather the proceeding with this kind of cases, the people might think even the mediation board is not required. It's better for them to go to court directly under this procedure, because less cost, less hassle, and they can get relief from court very easily. So thereafter, now you need to keep in mind section 5, as his lordship stated, it deals with jurisdiction. So if you file the action in the wrong court, the court can return the plaint to be filed in the correct court. In that instance, the time period from the date of filing of the action and date of return is excluded in computation of time period for prescription. But there is another situation where the plaint can be returned. That is under section 9. So section 9 says, in terms of section 46 of the Civil Procedure Code, section 46, subsection 2, there are two main provisions. Sections, if you look at section 46, subsection 2, it says, before the plaint by the plaintiff is allowed to be filed, the court may, if in its discussion it shall think fit, refuse to entertain the same for any of the following reasons, and may return the same for amendment then and there, or within such time as may be fixed by the court, upon such terms as the payment of cost occasioned by the amendment as the court thinks fit. So when you look at section 46(2), returning is not to be filed in the correct court. It's returning for the purpose of amending. So here, section 9 speaks of a situation where you can return the plaint. So that return has nothing to do with prescription, because your case, you have already instituted action and you're proceeding with the action. This is only for the purpose of amendment, the plaint will be returned. So at that time, you must be a little careful. Section 46 further says, once it is returned for a particular purpose and it is not done, then the action can be dismissed. So in such a situation, you're not entitled to file action afresh. So we need to keep that in mind. But of course, if you want to if there is any issue, the court can return the plain for amendment in terms of section 49 of this act. So thereafter, very important, section 10 says when the defendant on the summons returnable date, when the defendant is represented, or when the defendant comes to court, the judge shall ask. So it's compulsory on the judge to ask whether the defendant intends to admit the plaint with or without terms. So with or without terms. So this is what I said. So there could be a certain portion of the claim where the defendant is willing to accept. So sometime the plaintiff might say, okay, if the defendant is willing to accept that portion, I am willing to finish this matter, allowing the defendant to pay that amount. So there is a situation here under section 10 on the summons returnable date itself to settle the matter if the learned judge who is going to take up the matter takes interest, as well as the two lawyers who are appearing for the two parties take interest, the matter should be able to conclude on the summons returnable date itself. So this is something like section 72 of the Civil Procedure Code, where the claim is admitted and you can do that in writing, file in court. And there is a new section, a complete new provision that has been brought in this act. That is section 13.2. After filing of the answer, in the answer, the defendant takes up, or defendant sets out a claim in reconvention, and the plaintiff is willing to now accept the defendant's claim. So in such a situation, it is very similar. The provisions have been made, but we don't have that in the Civil Procedure Code. When the cross claim is admitted, when the plaintiff is willing to admit the cross claim, that also can be recorded in the same way as envisaged in section 72 of the Civil Procedure Code. But original Civil Procedure Code doesn't have the claim in the situation where the claim in reconvention being admitted. But only issue, as far as I can see, the section 13.2 says the judgment, enter judgment against the plaintiff in respect such claim. But the problem would be, I think we might encounter some problem here, because now we can't have two judgments in one case. One at the beginning of the trial in favor of the defendant, and one after the trial in favor of the plaintiff. So usually when there is a claim and a cross claim, when a claim and a reconvention, so there could be some kind of adjustment. So there could be only one judgment. But here, I believe a situation where the defendant is not pursuing, the plaintiff is not pursuing his claim, but only admits the defendant's claim, this probably will work. But in a situation where the plaintiff has a claim, defendant has a claim in reconvention, unfortunately, we say the defendant is not willing to accept plaintiff's claim, but the plaintiff is willing to accept defendant's claim. So then in such a situation, we may not be able to enter judgment. The court may not be able to enter judgment at the very outset, but of course you will have to proceed with the case. But the admission on the part of the plaintiff admitting the claim of the defendant should be able to record in court. So I feel this particular section we might need a little bit more clarity when you're fine-tuning in the future. We can pay attention to that. So the answer, now we finished the plaint, now we are coming to the answer. So as Justice Fernando very correctly said, the time period given for the answer is only 1 month. So we know in the district court, we take a lot of time, like the summons returnable date, we just don't even look at the case, go to court, file the proxy, get a date for answer, and you come. Then we wait for another month or so. And when the client comes, so when we come closer to the date, if we are not ready, if we haven't met the client, we might go to court and ask for further date to file answer. But you can't do all those things under the Small Claims Procedure Act, because the time period given is 1 month. So you are compelled to file your answer within 1 month and in appropriate circumstances. So that is the exception. So the rule is that you have to file the answer within 1 month. The exception is in appropriate circumstances, at the mercy of court, you probably will be able to get little for more time to file the answer, but that you won't be getting a date. The answer will be filed in the registry. Very good provision. Answer will be filed in the registry. So the filing of the answer, there won't be further delays under this particular act. So then, along with the answer also, you file all those documents, just like you file in the plaint. Along with the plaint, you file the affidavits. You file the affidavit in support of your averments in the plaint. You file further affidavits from other witnesses. You file documents. Same way, along with the answer also, you file all those documents. So once you file all those documents, if there is a cross-claim, now if there is a cross-claim, there is a date, the court will allow you to file a replication, not otherwise. But if you look at section 79, even if you don't have a cross-claim, if the court requires further clarification, if court is of the view that the party should be allowed to file further pleadings for better clarification or better clarity, the court can allow parties to file further pleadings. But under small claims courts, the Small Claims Procedure Act, you don't have that kind of opportunity. So you only in situations where, but even under 79, we hardly have seen in practice, people are making applications to file further pleadings. So I think it's a good provision. We have not entertained that here in this act. So the straight away, you fix it for compulsory settlement stage. So after filing of the answer, if there is a cross claim, and as I said before, if the plaintiff is willing to accept that, then you can still record that settlement, record the fact that the plaintiff is admitting the defendant's claim, and you can even enter judgment upon that, provided plaintiff is not proceeding or not pursuing his claim. So thereafter, and section 14 says, so this could be another issue, if the claim in reconvention exceeds the monetary restrictions of the Small Claims Court, the court will now have jurisdiction to deal with that particular claim, because the Small Claims Court has already assumed the jurisdiction of this over this action, over this case, and the court will continue to hear the matter. So there's no problem. So if you have a further, if your claim is exceeding 1.5 million excluding interest, you still can set up a cross claim in the Small Claims Court. Right. Then about amendment of pleadings thereafter, the section 16, Justice Fernando very clearly said, only limited circumstances where you prove in satisfaction of court that a grave and irremediable injustice will be caused if such amendment is not permitted, there is no provision to, there is no way that you could amend the pleadings. Now, this is actually very similar to section 93(2) of the Civil Procedure Code. You know, section 93(1), if you make the application or no before the day first fixed for trial, the court has wide powers to allow the amendment. But now here, the court doesn't have that power anymore. Under Small Claims the Procedure Act, you have unless you show that you have that a grave and irremediable injustice will be caused, you will not be able to amend. But of course, the proviso to section 16 very clearly says, if there is a correction in relation to clerical or arithmetic mistakes, clerical or arithmetic mistakes at any time in the proceedings, then and there court can do the correction. You don't need even to make a formal application to, by looking at this provision, that's what I understand. You don't even need to make a formal application for this. You can make an application orally in court, because the court has given that power to, the law has given that power to court to do the corrections when there is a clerical or arithmetic mistake in the pleadings. So that's about the pleadings. Then you come to the trial. So when you come to the trial, it's about, before you come to the trial, His Lordship, I think, he drew the attention to section 19 of the Act, where section 94 to 100 is not applicable in these provisions. So it says, section 19 says, section 94 to 100 of the Civil Procedure Code. Now, look at section 17. Now, section 17 is a very important provision. But this provision, as a practitioner, if you want to make use of this provision, you need to be ready for your case. You need to know your case. So if you have studied your case, if you have had your proper consultations with your client, if you know exactly what more that you require for to establish your case in court, you can make use of this section. It's actually a fantastic section. You know, under sections 8, under the Act, the Amendment, Civil Procedure Code Amendment Act, number 8 of 2017, the pre-trial stage or the pre-trial proceedings were introduced. I know the pre-trial proceedings did not work in the way that it was expected for many reasons. I'm not going to go into that now. But one of the provisions in that act that they introduced was 142E, 142EC, which says, an order to issue certified copies of any documents in the custody of any public office, public corporation, provincial council, or any local authority. Only 4 segments of institutions: public office, public corporation, provincial council, or any local authority. So those are the only places from which you could ask the documents to be tendered to court. But here, the drafters have gone beyond that. It says, certified copies of any documents in the custody of any public officer, public corporation, provincial council, local authority, bank, board, body corporate or unincorporate, partnership, hospital, medical institute, court, tribunal, or any such similar institution. What more you need? If you don't have the document, we all know as practitioners how difficult sometimes for us to obtain documents. If you have to get 10 documents from 10 organizations, we will have to summon 10 witnesses. Probably 10 witnesses will come on 10 different days because of the courts are also working under pressure. The courts also don't have much time. Sometimes just to produce a document, you can do only that for the whole day. And the next trial date might come in another 6 months' time. So here, if you know exactly your case, if you had looked at the plaint, the documents, the answer, the documents, the affidavits, and if you are ready for your case on the day when it is, before it is fixed for settlement, if you study the case properly, then you know exactly what more that you require for the purpose of establishing your case. So this section 17, you can even ask any person to produce the document. The court will make that order. So because of this, I think this particular section is a wonderful section. We should be ready we should be ready with the facts, and the situation of the case will have to be understood properly to make use of this section. So I will see whether I can speak about the rest of the things because of the time constraints. But what I would say is, if you have these documents in hand, section 22, when it comes to the compulsory settlement stage, everything is before court. So once the answer is filed, you don't have time to rest because the matter will be fixed for trial immediately, or for settlement thereafter, trial immediately. So if you want to make use of the provision in section 22 settlement, you need to have the documents. So you make your application properly and get all the documents. If you need commissions, whatever. So for an example, we say you have gone to a small claims court over we say an injury caused as a result of negligent driving of the defendant. So if you need a medical kind of examination, you ask for a commission to be issued to general hospital or some other hospital for a doctor to examine the witness or examine the patient and submit the report. So you have the report. So by looking at the report, whether your injuries are compatible with your claim can be seen by the other party, you can make use of section 22. Since we don't have much time, I will stop here and we'll see whether we can discuss further on these provisions in the next session. Thank you.
Thank you very much, sir. We have also received some questions from our participants. But before we go into those questions, can I ask you, Mr. Vikramanayake, President's Counsel, about the impact of Section 23, with particular reference to the pleadings? Now, you spoke about, sir, the requirement of the pleadings and how certain documents, etc., affidavits must be pleaded. I would also come to Dr. Fernando on that matter about the role of the judge under Section 23. Can we look at Section 23, sir, with regard to the trial, where at one point it will be needed to decide whether this case can be decided on the existing pleadings or further evidence is needed, because that is a new paradigm in civil procedure.
Correct. Now, when you look at Section 23, the first thing is we don't have a provision. It's not imperative on the judge who's taking up the trial to record issues. So without the issues, you go into trial. So there's a danger in going into trial without issues. So why this particular thing? Why the drafters have kept this provision like this, allowing parties to proceed with the trial without issues is, now you have all the pleadings, all the documents, probably 90% of the evidence before court. When you reach this stage, everything is on the table. So that no one is going to play this hide and seek game any further. So everything is on table. On the judge can see, the parties can see. Exactly in examining the documents and the pleadings, if at all, if you need to go into trial, on what question you need to go into trial. Now, this is like summary procedure. If you take the normal, the summary procedure that is in the Civil Procedure Code, the first stage of the summary procedure is the petition, the documents, affidavits are there, the defendant's statement of objections, documents, affidavits are there, and the once the case is stated to court by both the counsel, the judge will decide on what question, on what issue you need to have evidence. So you raise issues only on that and you proceed to trial. So this is a similar provision where on the face of the documents, on the face of the pleadings and the documents already submitted to court, if the learned judge can see that, or the parties are agreeable to take, sorry, to decide the matter upon or based upon the documents and the affidavits already filed, you don't need to delay that any further. The judge can straight away proceed to give the judgment. This is like arbitration. As we all know, sometimes we agree in arbitrations just to decide on the affidavits filed. But for that, we have a duty. The practitioners have a duty. First thing, the practitioners will have to be honest and honorable in preparing the affidavits. So you need to deal with your claim properly. You need to deal with your defense properly. Nothing wrong in you taking up whatever the defense that you have to take on behalf of your client. That is your duty. But of course, you must keep in mind, your mindset will have to be suited for this particular provisions or with this particular procedure in this act. So when you file pleadings, if you honestly and honorably state your case properly in your affidavits, and you support the claim with the other affidavits, the defendant is not going to contest it. So if the defendant, the counsel, because these are small claims, we should not forget that. The litigants may be, sometime for small claims, the litigants also may be poor. They may not be able to afford litigation. So we'll have to have that empathy. We need to have, that kind of a mentality in appearing in courts. In other jurisdictions, small claims court is actually not for lawyers. The lawyers are not allowed to appear. But here, we have got that opportunity. We can appear, especially the juniors can appear. But of course, we need to be ready to deal with it. Now, this is another thing when it comes to some of these companies. These companies also sometimes very unreasonable in their claims. So they will also have to make the companies understand, because if you try to be focused and you're not going to claim unreasonably from the defendant, the chances are there that the settlement could be entered on the first day itself. So you have to keep that in mind. Now here, though issues are not imperative, if the judge is of the view that of special matters involved, the issues will have to be raised. Then you can raise the issues and proceed to trial only on those issues. So then you actually lead evidence only in respect of limited areas. We say there is a document strenuously challenged by the other party. Now, you must keep in mind, the law says when you're challenging a particular document next to the plaint, you have to specifically challenge that in your answer. Otherwise, what happens is, if you just ask the other party to prove it, once the document is proved, the cost will have to be borne by the defendant. If you say that the plaintiff should prove that, or the plaintiff says that the defendant should prove, on the face of it, you see that, it's a it's not a document that has to be proved, but you, just for the purpose of delaying or something like that, you just ask the other party to prove the document. The court will ask that particular person to prove it by calling witnesses, but the cost will have to be borne by you. I have seen in the district courts under the Act number 8 of 2017 also, there is a similar provision, and the court already making orders. I have seen that. It's a very progressive provision. If unreasonably you ask the other party to prove the document, then you have to bear the cost. So here, what it says is the parties can agree to conclude the matter on the evidence placed before court already by way of affidavits and the documents. So if there is any dispute in relation to any matter where the evidence is required, then you can go into to trial. If you look at section 23(2)(c), if any additional evidence to be led is documentary, it is necessary to prove a document of which the genuineness is impeached by the opposing party. So then genuineness, we say somebody is annexing a document and the other party is impeaching the genuineness of that document. So then you have to prove that document. Court might have to allow that party to call further evidence, oral evidence, or further documentary evidence to be submitted, to be produced in court. So those are the provisions in section 23. Otherwise, it would be always advisable and be easy for parties to agree to conclude the matter on the affidavits and the documents already submitted. But for that, as I said, you have to be very careful in drafting your affidavits. If you try to put all sorts of unwanted things, other party might not agree to finish the matter with the affidavits.
At this point, I'd like to bring in Dr. Juan Fernando on this point. So now, when we look at section 23(2) compared with the earlier provision on settlements, where the court has to form an opinion and with the consent of the parties, the matter can be judged on the pleadings already filed, 23(2) is a slightly different section. I would like to ask you, sir, what is the judicial role expected of a judge at this point? When 23(2) is looked at, there are 4 limbs. Is it necessary to be satisfied that all 4 limbs exist? Or is it that some of the limbs must exist with regard to allowing parties to produce further evidence? Is it necessary, if the parties are not in agreement, that there must be further evidence or not? Is it necessary at this point for an order to be made? Can you elaborate, sir? Because this is a new section and I would like your input on that side with the intention of the Act under 23(2), sir.
Yes, I think that 21(2) has nothing to do with the provision in relation to the leading of additional evidence. Why 21(2) is there? Now, 21, I think you are referring to 21(2). Is that correct?
I referred to, sir, 21(2) to compare 23(2), just my view, because there I believe the opinion of the court as well as the consent of the parties is necessary as to whether a judgment can be pronounced solely on the pleadings. In comparison to 23(2), where it appears that the court has to form an opinion about the future of the case and whether there is necessity for further evidence. I'm comparing the same, so if it is a relevant comparison.
Yes. Now, 21(2) provides that when the judge is of the opinion, the first of all, judge will have to form an opinion whether on the available pleadings, affidavits, and the document, and whether he can pronounce the judgment with the consent of the parties without oral evidence. So for that purpose, the judge will go through the record and see whether the relevant pleadings are there, affidavits are there, documents are there, whether the discovered documents are there. That if a document is discovered, that discovered document will have to be tendered to court by an affidavit. So that is also an affidavit.
I see.
So if all the documents are before court, the judge will go further and to see whether the other party has challenged the genuineness of the document. Now, Section 25 is the answer. Section 25 of the Small Claim Court Procedure Act is very, very important. I think the similar section is found in the Civil Procedure Code. Section 25 says it shall not be necessary to adduce proof of any document tendered to a small claim court or discovered under the provisions of this act unless the genuineness of such document is impeached by the opposing party with valid reasons stated therefore according to law. Here, the document is annexed with the plaint or affidavit or replication. It is not challenged. It is not impeached by the opposing party with good reasons. Then, of course, further proof may not be necessary. So if all the documents are there, there is no objection, the relevant document has not been impeached by the opposing party with valid reason, then the judge is of the opinion, the judge will have to form the opinion whether the judgment can be pronounced without the oral evidence. Then the second requirement is judge will fix the matter for judgment only with the consent of the parties. Now, in certain cases, if all the documents are there, affidavits are there, the documents which have been discovered are also tendered to court by an affidavit, parties might say, well, we are not calling witnesses because all our evidence is in the form of an affidavit. So the parties may invite the judge to pronounce the judgment on the available document, pleadings, affidavit, and all the discovered document. Now, the important thing is that the judge will form an opinion. If the judge is of the view, no, this cannot be done without oral evidence, then he will fix the matter for trial and he will take evidence. Now, one of the important thing is, even if the judge decide that the judgment can be pronounced on the basis of the pleadings, affidavits, and the document, judge can't pronounce the judgment without giving a hearing. Now, judge will give a hearing. So judge will ask the party to make oral submission or allow the parties to file written submissions. So then there is a hearing. The parties can identify the relevant issues, the evidence. They will file their submission in detail, and the judge can pronounce the judgment thereafter. So that first thing is, the judge will have to form an opinion. Then judge will ask the parties, and judge will get the consent of the parties, and then give a hearing to the party. Then the judgment will be pronounced thereafter. So that this is a very important provision because if the parties are of the view, well, we don't want to lead evidence, we invite the judge to pronounce the judgment, and then the judge will allow the parties to make oral submission or allow them to file written submission, then pronounce the judgment. Now, Section 23(2) is a different situation. That's the situation where the judge will permit the parties to lead additional evidence either oral or document. That applies where the judge decides to proceed to trial. Section 23(2) applies to a situation where the judge has decided that oral evidence is required and the parties are allowed to lead oral evidence. Then in such a situation, even a witness who has not filed an affidavit, a document has not been annexed with their pleadings, may be allowed under certain circumstances. So the party cannot get up and say, I have not annexed this document, I have not filed an affidavit of a witness, so I may be permitted. Now, there are certain conditions to be fulfilled if the additional evidence is to be allowed by the court. The first condition is additional evidence must be relevant. If it is not relevant, the question of leading any additional evidence will not arise. So that it has to be relevant to the matters in dispute. If that is so, judge may consider. Then there's another requirement that additional evidence must be satisfied that additional evidence could not have been obtained or adduced along with the pleadings at the first instance with reasonable diligence and the best effort. And non-production is beyond the control of such parties. So those are the requirements. You can't just get up and say, well, I have not annexed that document so that I be permitted at this stage. And we have to remember, two early opportunities had been given. First, with the pleadings, parties can file documents. So they have to do their homework. Number two, even if they have not annexed those documents under Section 7, they can discover the document. Then once the document is discovered, that document can be tendered to court by way of an affidavit. That's a second opportunity. So that they had enough opportunities. So you have to satisfy first and the second requirement. Then the third requirement, additional evidence to be led is a documentary. It is necessary to prove that the document which the genuineness of the is impeached by the opposing party. Then if the document which is either annexed with the plain or pleadings or the discovered document which is submitted to court by affidavit is impeached, then of course the judge will allow that evidence. For example, during the course of the proceedings, a commission has been issued or some report has been called by the court, and the report comes and that is challenged by the parties with valid reasons. And then if the judge is of the view that this particular document, there is an issue about the genuineness of the document which has been impeached by the party, then that document may be allowed to be produced as additional evidence. Then there is a fourth situation, D, where the evidence of an official witness is involved, or witness who is unable to testify by way of an affidavit. Then the parties can take out the summons and call that witness. For example, a police officer, public officer, they may not give affidavit to the parties. So such affidavit will not be annexed with their pleadings. But then the court will allow a police officer or a government officer to be called as a witness because they may not be in a position to file the affidavit. There are many witnesses who may not be willing to give affidavits. So that then an application can be made to court and the court will permit additional evidence. So this is, that is the reason why this requirement must be satisfied by the party who is making an application for additional evidence to be satisfied. Now this applies when it comes to the question of trial. So before the trial takes place, there is no reason to consider this requirement. So section 23(2) and 21(2) are two different situations.
Thank you very much, sir. There is an interesting question from one of our members in the viewership as to whether the small claims court is a different court to the district court. I believe the question is with regard to whether physically there is a different court or it is the same district court wearing a second hat in the sense of the deeming provision, I believe, in the Judicature Act. Would you comment on that, Dr. Fernando, before I go on to Mr. Vikramanayake on some other question?
I would like to say no. It is not the same district court. If it is the same district court, there is no need for us to have an act, introduce a separate small claim court. But I must say the earlier small claim court, of course, it was established under the Judicature Act, had provisions to hear not only the monetary claims, but also some immovable property, matters related to immovable property as well, of course, under certain restrictions, under certain monetary limitation. But this small claim court is different. So in the district court, what are the pleadings? Plaint, answer, and the replication. Here, yes, plaint, answer, and replication, but there's a special procedure. You have to file affidavits, and you have to file documents. You have to file the affidavit of the witnesses. Then matter will be fixed for settlement, not for trial. And the settlement is a different settlement. It is not a pre-trial. It is a settlement conference for the purpose of resolving the dispute at the settlement conference. So it is not the same. And also we will find in the district court, there are so many provisions which have been excluded from the small claim court. For example, interrogatories are not permitted. Interrogatories are permitted in the district court. Here, interrogatories are not permitted. And also, one of the salutary provision is section 31(2). It says no proceedings in the small claim court shall be invalidated on account of the technicalities in the procedure or formal defect of irregularity in the pleadings, affidavit, or forms. And the judge of the small claim court, in his discussion and in the interest of justice, shall ensure that such technicalities will not impede the administration of justice unless substantial prejudice has been caused to such persons. So these are one of the most important provisions in the Small Claim Court Act. And I would also like to say the forms are different. Now, if you look at the plaint, Form 1, it is a different form. At the end of the form, if the plaintiff decide to abandon a portion of action, then plaintiff will have to plead that. The value of the whole action will have to be included. Then once the summons are issued, the plaintiff will have to file the plaint, copies of the affidavit, and copies of the document as well. Then if you look at the answer, at the end, defendant will have to file the copies of the affidavits and the documents. So there are major differences. So I would like to say this small claim court is different, but of course some of the provisions of the Civil Procedure Code also apply. So it has both formal as well as informal concept included in the small claim court, but it is not the same district court, or it is not the same district court procedure that is laid down in the Small Claim Court Procedure Act.
So logistically speaking, that would be the intention would be there would be a separate court and a separate judge for the small claims court and a separate district court for any judicial division. That would be the logistical intention of this act.
Just to the idea is in stations, in areas where there is high monetary value actions, there will be a separate small claim court judge who will hear the small claim. But you can't expect to have a small claim court in each district court area. because of this present economic situations, and it's not practically possible. But in stations where there are so many monetary claims, there will be, at least in the future, a separate small claim court judge who will hear cases in the separate courtroom. That is very important, especially for the purpose of conducting the settlement conference. The settlement conference, in fact, cannot be conducted in open court in the presence of all the parties. Now, in most of the jurisdiction, it is a private meeting between the parties will sit with the judge and the lawyers and will make their endeavor to settle the matter. So that it has to be a separate structure, a separate courthouse, separate judge, and there must be a separate conference table for the judge to conduct the settlement conference. So it's those are the requirements, I think, if we are going to have a proper implementation of this act.
Thank you, sir. Mr. Vikramanayaka, sir, there is an interesting question by one of our members as to whether, as to the question of certain specific types of money recovery procedures which are excluded from the Small Claims Code. I think Dr. Fernando spoke about some of them, like the Mortgage Act, Debt Recovery Act. There's a question about the Finance Lease Act, Act number 56 of 2000, as to whether that is an act which can be excluded on prima facie, sir, as to whether there is any specific procedure there is a question, as opposed to, say, the Mortgage Act or the Debt Recovery Act. What is your view on that, sir, firstly? And secondly, sir, if just to assist our practitioners, if somebody is filing a plate in the Small Claims Court, should the caption read in the Small Claims Court of Colombo or in the District Court of Colombo exercising small claims jurisdiction? Just a practical advice, sir, what would you say?
Dealing with your first question, Harit, as Dr. Fernando very correctly stated, I think what is envisaged in this act is to exclude the cases where you have to necessarily adopt a different procedure. Now, if you look at the acts, particularly excludes Section 2, particularly excludes actions under Chapter 53, summary procedure on liquid claim, because the procedure is different. So that is excluded. Then other acts that they're talking about, in my view, are acts like debt recovery law. Debt recovery law, the procedure is completely different. If you look at debt recovery law, even if the amount is less than 1.5 million, it would be favorable for the company to go under debt recovery law, because the debt recovery law says, now see, for an instance, the judgment itself is a writ, which is not a provision here. So once the judgment is entered, that works as a writ. That itself works as a writ. So it's quicker for the party who gets the judgment in their favor to execute the writ. Then when it comes to appeals, there is no direct final appeal. But here, under Small Claims Code, there is a final appeal. So then that, if you go under the debt recovery law, you will have to go by way of leave to appeal. So those advantages are there. So then you can't expect those cases to be brought under the the Small Claims Code. So debt recovery law is excluded. Then the Chapter 53 actions are excluded. And apart from that, the mortgage actions, because you are seeking an order from court to sell the property, the mortgage property, and there are special provisions applicable to those actions, because procedure is different, you will have to exclude. But when it comes to money hire purchase under Consumer Credit Act, or finance leasing, or the leasing actions under Section 56 of under Act number 56 of 2000, I guess, the Finance Leasing Act.
Yes.
Those are general money recovery action, except for the fact that you're asking for the vehicle or the leased equipment to be returned. That may be the additional claim that you make in those cases. But if you look at the 7th schedule to the Judicature Act, you can see one is the recovery of money. The second one is any action for the recovery of movable property. So the fact that you're asking for a vehicle or an equipment to be returned is something that you can claim from the small claims court. So if the value, the monetary restrictions are fulfilled, if the value excluding the interest is less than 1.5 million, the leasing and the hire purchase actions will have to go to the small claims court. And what was your second question?
Second question, sir, if somebody is filing a plate.
Yeah, it's simple because as I think Dr. Fernando, his lordship very clearly stated, the jurisdiction is completely different to the district court. But of course, if you're in a courthouse where the small claims court is coming within the district court, I personally think still it's wrong for you to say exercising jurisdiction, because when it comes to the cases under this law, the same judge is actually wearing two different hats. The particular judge sits there as the small claims court judge. So you can't say exercising jurisdiction because it's not just exercising jurisdiction. In that instance, the district judge acts as the small claims court judge. So I think it's always correct for you to say it's in the small claims court. And one more thing, Harith, I would like to bring it to the notice of our viewers. The section 121 and 175 in relation to the list of witnesses and the documents do not really apply in these cases. It's a section 24(2) specifically says that. So you don't need to file list of witnesses because you don't require that. But the problem is now, if you look at section 21(2), the small claims court judge will have to be satisfied that the matter could be adjusted or could be decided upon the pleadings already filed. Thereafter, the parties' consent will have to be obtained. So if the parties are not consenting, then where are we going to stand? So then it should come under section 23(2), because if the parties are not agreeable, then you will have to lead evidence. But section 23(2) permits you to call evidence only in very limited circumstances. So if these limited circumstances are not there, then though section 21(2) says parties' consent is required, I see it, or I think you actually don't need that consent. The judge will have to then automatically make a ruling under section 23(2), because if the court, we say the 21 and 21(2), when the judge is of the opinion that a particular matter is a matter that can be decided only upon the pleadings, the judge is of that opinion. So when the party's consent is sought, the one party is saying, no, I want to lead evidence. Then you come to 23(2). So then that particular party will have to satisfy court that the evidence that they seek to lead will come within the requirements of section 23(2). So if that particular party fails to satisfy court on this, you go back to 21(2), where the pleadings will decide the matter. So it's always, my personal view is, what I feel is, most of the cases will be decided upon the pleadings. And here, the fact that if you have not impeached the genuineness of a document in your pleadings, then you actually can't ask evidence to be led on improving those documents. This is actually last year in 22. There was an amendment to the Civil Procedure Code, amendment number 17 of 22, where for land cases, unless otherwise you impeach the genuineness of a particular deed pleaded in the plaint, you can't put that burden on that particular party to prove it further. So that law was brought in last year. So this is a similar provision, but that particular provision is only in relation to land cases and the notarial attested deeds. But here, for any document, unless you're impeaching the genuineness. So then, this is why it is important for you to put all your documents along with your pleadings, because the other party wants to impeach, then there is a procedure. But what happens is, if there is no cross-claim, if there is no claim in reconvention, then there won't be any further pleadings. So if there is no further pleadings, the documents annexed by the defendant to the answer, how to impeach it. there is no further pleading. So I personally feel to give more effect to the provisions of this law, it is good even for us to have a provision where you allow the plaintiff to file further pleadings if that particular if the plaintiff so desire to impeach any documents annexed with the answer and produced to court. So then if that pleading is there, then we know exactly at the time of the trial what documents will have to be proved. But as at now, it is only the plaintiff's documents that could be impeached, that the possibility is there only for the defendant to impeach the plaintiff's documents, but not vice versa.
Justice Fernando, I'd like to bring you in on somewhat of a controversial section that has raised our members' attention with regard to the transitional provision in section 33, sir. There is also a question whether the parties or the attorneys must move the court by any form of documentation to bring into effect the transitional provision, or as to which matters stand transferred. There is also controversy as to whether applications pending before the courts have to be withdrawn and freshly filed under the Small Claims Code. Can you provide us an explanation, sir, as to how section 33, the transitional provision, applies, sir?
Yes, Saranga, can I have slide number 6? Yes. Now the relevant section is section 33. Now what does it say? What will happen to pending cases filed in the district court, but before the commencement of the pre-trial, on the day preceding the date of the operation of Act. Act came into operation on 1st of January 2022. What will happen? The action is filed in the district court, where the monetary jurisdiction and the subject jurisdiction are both less than 1.5 million. Now, in terms of the provision of this Act and the Gazette issued, that this Act came into force on the 1st of January 2023. Now, the action is filed in the district court by way of regular proceeding, plaint, answer, and replication. There is no affidavit, document attached with the pleadings. But what is the procedure in a small claim court? Plaint, affidavit, document. Answer, affidavit, document. Replication, affidavit, document. The complete procedure is different. Then what will happen? There is no need in terms of section 33 for the lawyers to make any application. By section 33, any proceeding pending in the district court in respect of any matter within the jurisdiction of the small claim. But before the commencement of the pre-trial, on the day of the operation of this Act, such cases will stand removed to the small claim. It will be removed. So the court will send it to the small claim. So you don't want to amend the pleadings. It is thrown to us the parties to amend. The action is filed in the district court by way of regular procedure. That record with the same procedure will be removed to the small claim, where the action is, the value of the action is less than 1.5, and it comes within the subject jurisdiction of the small claim. So the action will be referred to the small claim court. Small claim court judge will follow the same procedure. Small claim court judge cannot adopt the procedure laid down in the Small Claim Court Procedure Act. This is what this section says. What does it say? All proceedings pending in the district court of any judicial district, but before the commencement of the pre-trial, on the day preceding the date of operation of this Act, in respect of any matter within the jurisdiction of the Small Claim Court, shall on the date of the operation of this Act stand removed to the appropriate small claim court. And such small claim court will have jurisdiction to take cognizance and hear and determine, continue the same in accordance with the procedure, in which the action was instituted. What was the procedure in which the action was instituted? In the district court, regular procedure in the district court. The small claim court judge will continue the same procedure where the pre-trial has not commenced. The pre-trial has not commenced on the date of the operation of this act. It comes within the small claim court jurisdiction. It will be removed. And the small claim court judge will act as a district judge, because the judge of the small claim court is also a district judge. And he will hear cases. Basically, he will conduct the pre-trial. Because if the pre-trial has commenced, those cases will not be removed to the small claim court. If the pre-trial has not commenced, then those cases will be removed to the small claim court. But then the procedure that will be adopted is not the procedure laid down in the small claim court. That is not possible, because the small claim court has a different procedure. You can't adopt the procedure in which the action was filed in the district court. So that small claim court judge will follow the same procedure. He will conduct the pre-trial. Thereafter, he will fix the matter for trial, and a district court procedure will be continued in the small claim. So he will be a district judge as far as those transferred or removed cases are concerned. You can't ask the parties to amend the pleadings. You send the record from the district court to the small claim. Can you ask the parties to amend the pleadings? You just forget about the pleadings filed in the district court and you file new pleadings. What will happen to the question of prescription then? So you can't amend the pleading. There is no need to amend the pleading. Record will be removed to the small claim court, and the small claim court judge will continue the same procedure in which the action was filed in the district court. So that's what Section 33 says. So there is no need, and it is wrong also to amend the pleadings in the small claim court. That's really a misconception. It's wrong. There's no need. Section 33 is clear.
Thank you very much, sir. I'd like to, before we go on to our final comments, ask about the role of costs in small claims. If you go to litigation for 1.5 million, you don't want to end up spending 500,000 or 250,000 and not recover that amount. Has the small claims court changed the concept of costs, where actually what you incur as expenses and litigation costs can be asked for at the point of judgment, and the evidence can be led in the trial itself? I believe there are provisions for that. Can I have the comment of Mr. Vikramanayake, and if Dr. Fernando also can comment on that? Has there been a change in the way?
I think we need to give a proper thought to that, Harit, because if you look at Judicature Act number 34 of 2022, Section 29C says, it shall be lawful for the judge of every small claim court in pronouncing his order or judgment in any case to make such order in respect of the payment of costs and expenses as to him shall appear just and reasonable. So for court to arrive at a decision like that, there has to be some kind of evidence in relation to cost and the expenses. Without the evidence, obviously, court can't arrive at that decision. But the problem here is the cost that will incur by parties will continue until the case reaches the stage of the judgment. So then if we are looking at a regime where 99% of the cases to be concluded, or majority of the cases to be concluded on the pleadings, then at the time of filing the plaint, it is not possible for a party to file documents pertaining to cost. Probably even at the time of filing the answer, the defendant may not be able to submit documents pertaining to cost. So practically, if we try to bring in this cost issue into the trial, I think the spirit of this act is lost. So probably we will have to allow the judges, either we will have to introduce some kind of a some kind of a method in calculating the cost without evidence, looking at the pleadings, because actually what could be recovered by way of cost is what is permitted by law. So those things are there. I don't think you really need to produce evidence, but of course the judge can take cognizance, because everything is placed before court, cognizance of the fact, the cost and the expenses, and make a ruling under Section 29 as envisaged by Section 29C of the Judicature Act. But if you try to lead evidence along with the plaint or the affidavit by way of pleadings, I personally think it may not be in line with the spirit of the law.
Justice Fernando?
I think by introducing this Section 29C, the drafting committee did not want to introduce a new concept for the recovery of cost. It is the same section, same provision in the Civil Procedure Code that will be applicable, because in any event, the estimate for the cost will be submitted at the end of the case. Now here, Section 29C refers to a situation where a judge in delivering the judgment will take into consideration the cost and the expenses incurred by the parties. But here, the judge will, of course, might order cost having regard to the facts and the circumstances of the case. But by this, I do not think that we wanted to change the relevant provisions of the Civil Procedure Code as to cost. I think there has to be a mechanism to amend the relevant provision of the cost. But I don't think that small claim court was a mechanism to make a completely change of the cost recovery procedure. So probably, I think, first of all, I think we'll have to amend the relevant portion of the civil procedure and introduce some sort of new scheme for the recovery of cost. So at present, the same provisions, I think, will be applicable, even though the judge is in a position under Section 23 of the Act to make an order for the payment of cost and expenses.
My penultimate question, sir, is there is a question. Mr. Vikramanayaka mentioned this issue as to whether originals of documents must be submitted. Several practitioners have been asking that same question. In your view, sir, should the original documents be produced, or is it sufficient to provide a true copy or duly certified copy with the pleading?
Yes, I don't think that by introducing this act, the drafted envisage that the original document should be annexed with their pleadings, and as we all know, there's a risk involved. Unlike in the debt recovery matters and the mortgage matters, what is important is to annex the copies, basically the two copies of the document, and to produce the original for the purpose of the settlement conference and the trial of the action. You can't expect the parties to annex all the original. That is not what is expected by introducing this Section 8. Section 8, of course, provides that the parties will have to produce instrument, contracts, agreement, bills of exchange, promissory note, checks, and other relevant document, and all other documentary evidence. It does not mean you have to produce the original documents themselves. It is not necessary. But of course, you must have the originals, and for the purpose of the settlement conference and the trial, you have to bring the original. And in any event, if the document is not impeached, the question of producing this original may not arise. So I don't think we intended to impose any burden on the lawyers and the parties by Section 8 that only the original should be annexed. Otherwise, the plaint order will be rejected. That is not possible in a small claim court. And these are not real issues. We are not expecting to impose a obligation on the parties and produce originals. Otherwise, the plaint will be dismissed. That's not the That's not the idea of having the small claim court. If that is so, the whole idea of this having a small claim court will be lost.
Thank you, sir. I think by this session, we've had a very interactive session about what the small claims procedure is, and there are several creases to be ironed as we go along. In fact, from our preliminary discussion yesterday, Mr. Vikramanayaka, we discussed whether we could have practice directions and guidelines within a consultation between the bench and the bar. And in fact, our secretary, Mr. Bala Patabadi, and Mr. Salih Piri, President's Council, the president, was very amicable with that idea, whether we could have some committee of the bench and bar for the implementation of the small claims code. As a concluding remark, sir, would you think that's a way forward so that we can customize or have some uniformity in the way this procedure is implemented in the country, to avoid various decisions and various interpretations coming through, which may scuttle, in fact, the real intention of the small claims procedure?
I think there has to be practice direction and the guidelines to be followed. And most of the countries where the small claim codes are functioning, take, for example, Canada, Nigeria, South Africa,
New Zealand,
and various other countries, these small claim courts are functioning very well. And I must say, when they introduced the small claim court, they did not want the lawyers to appear. They wanted to have a 100% informal mechanism. But Kenya, for example, in their original act, they did not want the lawyers to appear. But recently they amended that and they allow the lawyers to appear. In certain countries, they don't allow the lawyers to appear, but they allow the lawyers to draft the pleadings. But they allow the lawyers to appear in appeals. Why is that? We need lawyers. Without lawyers, this will not be a success in our country. Of course, so that's a reason. But then the lawyers and the court officers all should be given a training. There must be a practice direction to be followed by all the people. That is why in those jurisdictions, they have not only the small claim court, they have practice direction or the guidelines to be followed and the checklist. The checklists are very important for the lawyer before filing an action. Checklists are very important even for the court before conducting the settlement. A settlement is a different process. It's a very private meeting, but checklists are important. So that what I say is there must be a practice directions or the guidelines to be followed by the lawyers and the court officers. And there must be training of the lawyers, the judges, and even the court officers. This is a new concept. So we have to support this. It's a really challenge, but we need some other promote this system.
Mr. Vikramanayaka, sir, any concluding comments on that matter?
I think, as you correctly said, like there are little things here and there that we need to, iron out. But other than that, it's a very nice, very, very progressive piece of legislation. We all, as lawyers, support this and help the system to survive without a problem. And I'm telling all the juniors to take interest in this law, go through the procedures, compare this with the civil procedure provision, and be ready to conduct trials, be ready to conduct cases in the small claims court. We must discourage seniors as much as possible from appearing in the small claims court, and we must allow the juniors to have the small claims court, because it's going to be a wonderful experience for them. And thank you very much for the Bar Association for organizing this. I'm sure this will help many juniors to start their practice in the small claims court.
I think
Haritha, can I show you a slide, last slide? That will be very useful before we conclude.
Of course.
Now, this is the last slide I want to show. It is a challenge. Small claim court is a challenge. You need dedication, commitment, hard work, and sacrifice to make it a success. It was an unborn child last time, because it was the last time the small claim court was not established, not implemented. So don't make it a disabled child this time. Give it a chance, because the people of this country need a change. Thank you.
Thank you very much, sir. Wise words indeed. The people need it. And I think the lawyers need to realize that and implement it for the betterment. And with that, ladies and gentlemen, thank you very much for joining us on this webinar of the Bar Association for 2023. I thank the most esteemed panelists for their wonderful contribution. The members are very thankful as well. And I hand it over to Kavishan to conclude. Thank you.
Thank you, Harit. So on behalf of BASL and the seminar committee, I would like to thank Honorable Justice Dr. Ruan Fernando, President's Counsel, Mr. Jagat Wickramalayaka, and our moderator for the day, my good friend, Attorney at Law, Mr. Harit Dimel, for this very informative and a valuable session. I think it was very valuable for us fresh lawyers to understand about the small codes. And I would like to thank all of you who joined us through Zoom and YouTube, and for your questions that have made this webinar an interesting one. And I'm told that this might be the last session for 2022-2023. And I would like to take this opportunity to thank the seminar committee for the tremendous job they've been doing throughout the year with these valuable seminars. So our gratitude goes to Chairman, Mr. Isuru Palapamedi, Convener, Mr. Pandula Wanyarachi, the co-conveners, Ms. Nikini Mapitigama, Ms. Adisha Disanayaka, Ms. Dilhara Jayasekara, Ms. Divya Atpudanathan, Ms. Pasiduni Fernando, Ms. Deshani Bandara. So this is the team who has doing all this tremendous work behind scenes to make this webinar series a success. So thank you very much again. So that concludes our session for today. Thank you again for joining us. Good night and take care till we meet again. See you.